Hello, everyone, and welcome to this month's webinar, Navigating New Employment Laws, a 2025 update. This free webinar is available for all WorkWise Compliance customers. I'm Stephanie Balicki, the Product Operations for WorkWise Compliance. I'm joined by my co-moderator, Dan Hilfrich, who serves as our Senior Human Resource Manager.
Hello to all of our attendees. Today's webinar will present important information, both new and updated at the federal and state employment law level, effective in late 2024 and early 2025. After a brief discussion, you can consult with our guest attorney on these key laws in our live Q&A session.
That's right. And so today's webinar will explore the following topics and any new employer obligations created under recent legislation. So we'll go over an overview of the 2024 election results and what this could mean to employment law landscape, general labor law topics such as recent crackdowns on workplace contract provisions and the removal of the non-compete agreement ban, wage and hour rules involving the elimination of the new overtime rules provisions, and workplace safety obligations, including updates to the hazard communication standard and a new final rule on personal protective equipment proper fit requirements.
We'll also be covering harassment and discrimination updates, such as new guidance released by the Department of Labor involving artificial intelligence and inclusive hiring, benefit plan compliance, including updates to benefit plan reporting and filing, and final rules on access to substance use disorder and mental health benefits. We'll also talk about other recent updates, including important recent California and New York law enactments. We'll wrap up the discussion with the 2025 minimum wage increases.
And in the final moments of our webinar, our guest attorney will answer as much as time allows, some audience questions live, providing you with the invaluable experience of engaging with a legal expert on critical issues. Our speaker will also offer key takeaways from today's session while we engage the audience with poll questions throughout.
And in today's webinar, we're hosting a special guest attorney to cover the importance of staying informed about recent updates to the employment law landscape. Our panelist has frequently acted as a guest speaker in our past webinar. I want to welcome back attorney Jeff Fucci. Jeff is a graduate of Vermont Law School and is the founder, CEO, and lead attorney at Fucci Law, J Fucci Law LLC. At that firm, he serves as a trusted business advisor, consultant, and in-house counsel for various businesses ranging from startups to large corporations. Before establishing J Fucci Law, Jeff gained valuable legal experience working at big law firms in the New York City metro area, serving as a judicial law clerk in New Jersey and serving as an adjunct law professor at Seton Hall University, where he attended undergraduate and graduate schools before earning his JD. Welcome, Jeff.
Thank you, Dan. Thank you for having me, Dan and Steph. It's good to be back. You know, many of my business clients are entrepreneurs and managers across various industries. Now, I offer my services here at J Fucci Law in counseling these entrepreneurs and business leaders on labor disputes, employment negotiations, anti-discrimination and other workplace policies, contracts, and federal, state, and local government regulations. Knowing about changes and additions to the employment law landscape is extremely important for all of the businesses I work with, and I look forward to discussing recent labor law changes with the audience gathered today.
Thanks, Jeff. And before we proceed, we want to ensure everyone can hear and see Jeff clearly. If you have audio issues, please check the volume on your computer or mobile device. If that doesn't solve the problem, just let us know in the chat and we will work to improve the audio as best we can.
All right, and at this time, we'd like to go ahead and ask our first poll question. Today's webinar session is heavily dependent on audience participation, so to ensure that we're prepared to fulfill today's hour with helpful content, we'd like to know, what are you most interested in hearing about today? Information about the 2024 election's possible impact on employment laws, general labor law topics, wage and hour rules, workplace safety obligations, or harassment and discrimination updates? I'll give you all a few more seconds to answer. All right, and based on the results, it looks like we have a lot of interest in the general labor law topics for 2025 and the 2024 election's possible impact on employment laws. So we'll try to take a little bit of extra time to cover those specific topics today, and thank you to everyone who participated.
Thanks so much. And as your Q&A session co-moderator, I'll direct any audience questions to our guest speaker. These include questions submitted during our live session and any questions submitted during the webinar registration. Please keep in mind that your questions may be slightly modified before being presented to the subject matter expert. And the purpose of this webinar is to provide accurate and authoritative information on the subject matter being discussed. It does not constitute legal advice. Depending on your state, type of business, and number of employees, the tips and laws discussed today may require you to take specific actions. We recommend working directly with legal counsel and your human resource professionals on matters pertaining to your business. WorkWise Compliance, the webinar host, and our guest speaker are not liable for any errors, omissions, or changes in law or advice that lead to unfavorable outcomes.
And for attending this webinar session, WorkWise Compliance is offering our 2025 New Year, New Laws e-guide. This resource includes more information about the topics we'll discuss today, including important links to agency news releases and full versions of regulatory text and guidance. This resource also includes a state-specific new law chart, which includes any new laws affecting specific states. A short description of each law is included, as well as links to the regulatory text. As an attendee, you'll also receive the 2025 minimum wage map, which includes minimum wage information for states with recent changes. Today's slide presentation, equipped for note-taking, is also provided to attendees. All of these resources are available in the materials section of GoToWebinar. At the end of the session, you'll receive a downloadable certificate via email as proof of your attendance today. Also, I want to invite everyone to submit any questions you may have during the presentation by using the Ask Question feature in GoToWebinar. Most questions will be saved for the end of today's session. Still, those relevant to the discussion may be posed where appropriate. With that, let's get started with today's session. Jeff, let's start with an overview of important law changes in 2024, please.
That sounds good, Dan. Federal and state labor and employment laws both substantially evolved during 2024. Broadly speaking, the labor law field continues to see changes in employee and independent contractor contracts for private and public employers alike of all sizes. This is specifically true of non-compete agreements, tracking technology use, and AI. Additionally, we will discuss some revised wage and hour and workplace safety rules. The subjects of equal employment opportunity and benefit plan compliance will also be addressed today. Finally, noteworthy changes continue to come from the labor law leading states of New York and California, and we will look at some of those regulations as well. As always, where we see changes to the legal landscape, a rise in employment litigation can be expected to follow as rules are applied, enforced, and challenged. In fact, we saw this happen just last year in 2024 with federal bans on non-compete agreements and clauses in employee agreements being set for widespread implementation by the federal government through its agencies, only then to be overturned by the same federal government through its courts. We will explain how this works more in detail shortly. The most important concept that I want to leave all of our attendees with today is that it is highly advisable and will save the businesses money in the long run if each company reviews its existing policies to ensure compliance with the latest labor and employment laws we will discuss.
Yeah, that's a good point, Jeff. And I'm sure our viewers are ready to get into it. So let's begin with an event that certainly was on everybody's mind late last year, and that's the 2024 national elections. Can you please discuss how the results might affect labor laws in the near future?
Sure, that's a good place to start, Steph. A lot of employers are wondering what the election results mean when it comes to future labor law enforcement. Generally, due to the 2024 presidential election, President Donald J. Trump took office with a politically conservative United States Supreme Court justice makeup of 6 conservative to 3 liberal justices. Now, this has to do with what president appointed those justices during what administration and what those justices' rulings at various levels of their judgeship, so to speak, what those rulings came down like. So that's how we determine conservative or liberal based upon perhaps a situation where you might expect the judges to be nonpartisan. They are, however, interpreted that way based on their previous decisions and what president appointed them. As many people know, President Trump was able to get several appointments in his last presidency when he was the 45th president of the United States. Now, President Trump also took office at a time when both the House of Representatives and the U.S. Senate, based upon the 2024 election, have both now shifted to a more than 50% conservative majority. This single party control of both the presidency and the Congress creates what political scholars have come to call a unified government, which can make enacting and enforcing new laws easier than when there is a divided government. In other words, different branches having different parties. It's important to note that unified governments, however, have previously existed in the United States, including as recently as the presidency of former President Joseph Biden, which saw a unified government under Democrat control between years 2021 and 2023. Since a unified government and an overall change in the ruling party both have resulted from the 2024 election, it would be reasonable to expect a legal and potentially a cultural shift to accompany this now Trump presidency. However, we will have to see what happens, as President Trump only took office as the 47th president this week.
Thanks for that update, Jeff. You're right. With the current presidency just beginning, I'm sure that within the next couple of months, any changes the government wants to make will begin. On that flip side, let's talk about some laws and regulations that we already know are in effect or will be in effect shortly. Let's start with some general labor law updates. I know there have been some big updates recently.
You're right, Dan, and that's a great insight. Let's go over 4 topics that I think are very important regarding labor law generally. The first item I would like to discuss was just announced and went into effect last week on January 15th. The Federal Department of Labor, who we'll talk about a lot today and also references the DOL, made its annual civil monetary penalty adjustments for year 2025. The changes are required under the Federal Civil Penalties Inflation Adjustment Improvements Act. Specifically, the Act allows any civil monetary penalties to be evaluated yearly using a cost of living formula. The annual adjustments are made to deter employers from violating the labor laws in question. So basically, if you are found to have violated a labor law, the amount you could be fined has increased. What's the solution to that? Don't violate labor laws. In general, the adjustments cover several penalties for violations of labor laws that apply to a wide range of employers. The laws I am speaking about today fall under the DOL enforcement. Other government agencies will also have released their adjustments last week. Usually, most of these changes are announced in mid-January, so this is very common. In the interest of our current webinar audience, the violations and subsequent adjustments to the civil penalties are now showing on the screen, and these may interest you.
And as a reminder, all attendees can access copies of our slide presentations in the materials section of GoToWebinar. Please continue, Jeff.
Jeff,
Yes, and
this
that's
is
a very helpful set of resources provided today by WorkWise, and that will be helpful for all of the attendees to use. Now, in 2024, the DOL issued a warning that the agency planned to investigate workplace contract provisions that may be seen as coercive or otherwise in violation of labor laws. 7 specific provisions were identified as targets for the DOL's enforcement. In light of the agency's publicized notice, employers are advised to avoid adding the following types of provisions to their employee contracts. And we'll go through them now in sort of a little bit of a list that you can also see on your screen. These provisions are as follows. Employers should try to avoid requiring workers to waive their wage and hour rights, incorrectly classifying workers as independent contractors when those workers are in fact employees. They should avoid shifting liability for a company's legal obligations or for third parties, perhaps clients that the company services, to workers. They should avoid requiring fee shifting, rather, if the employee is a losing party in litigation against the company. They should avoid requiring workers to either stay or pay. For example, where workers who resign must pay relocation costs or training costs back to the company. They should avoid requiring confidentiality, non-disclosure, or non-disparagement on specific topics that relate to an employee's legal right to report on workplace issues. And they should avoid requiring workers to report safety concerns to their employer first, before going to a government agency with oversight of such matters, like OSHA. Finally, the DOL warned that attempting to bury prohibited provisions in the fine print of contracts would be no defense for companies that did so. The agency aims to protect workers from unfair bargaining practices by their employers, and contracts being heavily steeped in fine print or complex legal structuring or provisions will certainly be a red flag.
Jeff, I think we have a delay on your end. Do you mind turning your camera off and on? Maybe we can try that and we'll see.
And while it's no longer enforceable, let's go on to another
The
subject
audio is
that did get a
still
lot of news coverage
quite a
last
bit
year.
delayed.
20,
We are still delayed
how about now?
here. Try it again. All right, so Jeff will be right
How about
back. I
now,
think,
everyone?
I think that's better. Maybe not.
well, while maybe Jeff
Yep.
can leave for just a moment. Maybe did you want to do a poll question so Jeff can leave and re-enter to reset everything? All right, so which of the following would you like more information on? The legalities of workplace contracts, what can and cannot be included in a non-compete agreement, the use of AI in the employment decision-making process, or none of the above? And we'll give everyone a moment to answer there. Jeff, are you back in? You want to test your audio, see if we're working now?
Can all hear me?
Like are you hearing that delay, Dan?
Yeah, it's a slight delay.
Okay, we'll have to work around the slight delay. So just give us a second to pause and then we catch up to you. All right, so we ended the voting here. It looks like a kind of a good spread, but people want to know more about AI and the legalities of workplace contracts. So that's really good. Thanks for answering that for us. That helps us know what information to pass along to our subscribers and members. All right, so with that, Jeff, what's the next topic that you'd like to discuss?
Sure. Thanks, Stephanie, and thank you to our to Dan and Stephanie and to our attendees. I apologize for any technical issues. I'll just take responsibility. I'm not really sure, but I'll take responsibility and I'll keep us rolling through, allowing for that delay. Although it's no longer enforceable, the next subject we'll talk about did get a lot of news coverage last year, particularly. In August 2024, a Texas federal court struck down the Federal Trade Commission, or FTC's, proposed ban on non-competition agreements and non-competition clauses in employee agreements nationwide. This happened just as a new FTC rule was set to take effect on September 4th. The result is that employers can continue to maintain non-competes to the extent that their state laws that apply to them allow. In general, the federal court determined that the FTC lacked the power to issue its new rule and that the rule itself was what's called arbitrary and capricious, a legal term meaning the rule was not supported by sufficient evidence, did not consider all of the data, and reached too broadly, among other stated concerns. The court also determined that its decision should affect all employers nationwide. Without a different determination from a higher court, the lower court's decision stands. As we mentioned before, the state of non-competes is currently left subject to state-specific restrictions only. From a federal standpoint, employers can continue to use non-compete restrictions to prevent competitive activities by their workers during and after employment and to protect confidential information, key business relationships, and trade secrets. While the FTC is not currently appealing the court decision, the agency may continue to work with state governments to conduct audits and investigations of non-compete agreements and clauses in all employee contracts for compliance with state laws that are still in effect. In some instances, like in the state of California, states may have laws that restrict or severely limit the scope, duration, and other aspects of non-competes.
All right, thank you for all that information, Jeff. You bring up a great point in general about state laws possibly not aligning with other state or federal laws. Here at WorkWise Compliance, we have employees who work in multiple states across the country. I would strongly advise employers and HR directors to consult with
Just
their
leave a moment
company's
for our
legal
delay.
counsel
We'll keep going.
if they have questions regarding what laws apply to employees based on the worker's location. Now, what's the last general labor law update you'd like to discuss, Jeff?
Did we lose the audio completely, Dan?
I think we lost the audio completely. I guess technology doesn't quite work exactly how we want
The
it to
next
all the
topic
time.
may not apply to
Oh,
everyone gathered here today, but it involves
perhaps we
artificial
have a
intelligence, or
dial-in number
AI,
that
for
Jeff can
job-related
work
decision
through.
making. And I'm sure a lot of our audience today feels that even if it doesn't apply to them, it may be just around the corner. So watch out. With the constant growth of AI in our everyday lives, this information.
All right, Jeff, let's try turning off the camera then and see if the audio comes through right away or not. There may be a phone number that we can get him to call in through as well, to kind of avoid this big delay. While we wait for him to connect, do we want to do another poll question for our audience? Okay, does your company utilize artificial intelligence or AI in hiring and recruiting? We have yes, no, but we're considering it. No, we will not be using AI, or I'm not sure. I know a lot of
Can
these,
you folks hear me?
Yeah,
we can hear you now. Can you hear us in real time? Not in real time. Jeff, there should have also been a phone number in the webinar invite that you should be able to dial in if needed. All right.
um, while we wait, I could go off on a short tangent about the multiple states. I think that's one of the most exciting parts of HR in the last couple of years. Since COVID, and everybody's been able to work remote, a lot of people have thought that means you can just live wherever you want throughout the
I can
United
hear you.
States. Can you hear her now, Jeff?
Go on, Dan.
Okay. Well, anyway, yeah. So people think they can just kind of move wherever they want within the United States, but it turns out that a lot of the employment laws pertaining to employees relate to where they live, not where the headquartered location is. So it's really important to check with your HR representative, even legal counsel, before having employees move to other states. For example, if we're here in Florida and we have an employee up and move across the country to California, they're going to have a lot of different laws, including different sick time requirements, different vacation time requirements. There's a lot involved, even with pay. So that's something post-pandemic.
I'd like to see if you guys can hear me.
We can hear you, but I think you may need to turn the audio off on your computer.
Understood. How about now?
Yes, we can hear you.
Okay. I'd like to just apologize for those that didn't hear it before. There's a little technical difficulty. Very glad to be here. Sorry about the tech. We're coming in from several different locations with a variety of experience, but I apologize, and I'm happy to still go through this and answer any questions anyone has. So thanks for being patient with me here. Let me know where next to pick up.
Yeah, go ahead and pick off right where you left off.
We were on the
Absolutely.
AI.
I got you. We were talking about AI, which may actually be responsible for our technical troubles. Who knows? Maybe AI has caught up to us. But we are concerned in the employer landscape about the role of AI when we talk about making decisions that rely upon this technology and this resource in terms of things like hiring, and then adverse employment actions, which we'll talk about a little bit later, things like firing, demotions, reductions in pay. things like that. Now, not everyone's going to think that AI applies to them, as we said, but anyone who's using AI technology and job-related decision-making at the employment level should be concerned. With the constant growth of AI in our everyday lives, this type of situation is likely to apply to many of us in some capacity before we even know it. Now, in October of 2024, the Consumer Financial Protection Bureau released information on restricting the use of workplace tracking technology as defined under the Federal Fair Credit Reporting Act. People might have heard about this in their ordinary lives because that comes up a lot with things like credit scores. Specifically, the guidance that came from the federal government targets employers' use of AI in data gathering processes and job-related decisions. Employers must consider the FCRA when accessing consumer credit report records when interviewing, hiring, or running background checks on job candidates. The information collected from consumer reporting agencies during queries may include such things as creditworthiness, credit standing, criminal history reports, driving records, and general reputation and character information. Companies sometimes purchase this data when making employment-related decisions. And when companies purchase this type of information, the CFPB's latest guidance requires the steps shown on the present slide. And these are: workers must give consent to employers who are purchasing reports about them for use in employment contexts. Employers must provide detailed explanations to workers when they make adverse employment decisions, as we stated, things like firing, denying a promotion, demoting, or other types of decisions that negatively affect the worker's work experience based on these types of reports. Companies must delete or correct information brought to their attention by an employee as information that is inaccurate, incomplete, or unverifiable. Employers cannot use data from reporting agencies for any illegal purposes, including selling the data on the open marketplace or using the data to sell financial products to workers.
It's great information, Jeff. And we asked a poll question earlier, and I think I saw on there, and it looks like, let's see, we did get some. Oh, here we are, right back on the board here. We have what everyone is interested in. So thanks to everyone who responded in this and for bearing with us through those tech difficulties, but it just helps us create information that's most relevant to our customers. All right, Jeff, let's move on to recent wage and hour changes. What new laws do you think our audience needs to know?
Sure, Stephanie. There's one major thing that happens, and I think our attendees need to be aware of it, and that's the rescinding of the most recent overtime exemption rules. Now, we're going to go a little slow here because we're going to throw some legal terms out, and we'll want to stop along the way to just make sure everybody understands what they are. So bear with us. This past November, another ruling came out of Texas. The Texas federal court has been very active in striking down some of the laws that were passed during the Biden administration. And what they did was they struck down the DOL's recent rule, raising the minimum salary requirement to be paid to most employees who are classified as exempt from overtime and minimum wage requirements under the Fair Labor Standards Act, or FLSA. So you might hear there about exempt or non-exempt employees. That's a distinction that comes up a lot in the employment context. And what exempt means is that these employees fit in one of the categories where they receive a fixed salary, the salary meets a certain threshold amount, and the employee performs, and these are also legal terms, either executive, administrative, or professional functions. There are three tests that govern which workers would have benefited from the DOL's wage increase rule in 2024. The DOL announced in early 2024 that it would raise the minimum salary for exempt workers in two phases. You can see those amounts on the slide now. Certain highly compensated employees would also receive a salary increase under the DOL's new rule. But under the current state of the law now, in January of 2025, the court's decision blocked the increases that were scheduled to go into effect this month, January 2025. The court also looked back and overturned the increases that went into effect on July 1st, 2024. Like we mentioned, it was two phases. And this rule actually applied not just to people working in Texas, but to all employees nationwide. However, employers are advised to exercise caution if they're considering any salary decreases for employees who benefited from the first increase that occurred in July 2024 under the rule. And that's because employers in that situation could be seen as taking adverse actions against the employees by docking their salary and reducing it to something lesser. And if that gets kind of bound up in the context of other things that are occurring in the employee's working situation, that could lead to litigation. So to be careful about these decisions, our employers are advised to discuss any potential changes to salary with their internal legal counsel. And they should also talk to their legal counsel about whether the states that they operate in have their own minimum wage requirements and their own definitions of exempt and non-exempt employees, because this is very important. And these companies should consider and discuss these issues with their internal legal counsel for more information.
Thanks, Jeff. And in the interest of time, let's switch gears here and move on to updates in workplace safety. I do know that OSHA has recently released a couple of new final rules.
That's correct, Dan. Let's be safe and let's get into it. In May, a final rule created by OSHA was announced that updated the previous version of the Hazard Communication Standard to better protect workers by improving the amount and the quality of information that's provided on labels and safety data sheets. The rule also allows workers and first responders to react more quickly in the event of an emergency. Physical hazard classes were also updated to better inform users on safely handling explosives, aerosols, and chemicals stored under pressure. Precautionary statements that employers keep on site must also now be updated to update the information that's included about safely handling, storing, and disposing of hazardous chemicals. This final rule went into effect on July 19, 2024. The second final rule was passed just last month and contains updates to the Personal Protective Equipment, or PPE, standards for workers working in the construction field. Specifically, the updated OSHA standard requires that PPE properly fit any construction worker who needs it to improve protection from hazardous conditions. Anything wearable that OSHA has any regulatory oversight and that's needed to protect workers during their daily jobs could easily be considered PPE subject to the rule. This matter has long-standing been a safety concern in various industries, particularly among women and physically smaller or larger workers than perhaps the average size that the gear is designed for. This final rule went into effect last week on January 13th. However, it's important to note that OSHA also has PPE standards for all of the industries, not just for the construction trades that we talked about at the beginning of this segment. All employers should be sure that they comply with the PPE standards that OSHA provides for their specific industry.
Thanks, Jeff. That's definitely some relevant news. And in recent years, heat and heat-related illnesses have become a topic of conversation in the workplace. And I understand those talks are continuing on the federal level. What can you tell us about that?
You're right, Stephanie. And I think that there's some science out or some news out that 2024 may have been the hottest year on record. And I feel like a broken record saying that because I feel like almost every year the climatologists tell us just that news. So in response to that, the federal interagency group that's called the National Integrated Heat Health Information System, which is a collection of agencies from the federal government all working in tandem to try to look at this heat situation for workers. That group recently released a national heat strategy covering the years 2024 to 2030. This strategy promotes proactive heat planning, heat response, and heat resiliency coordination. Such planning is especially important for employers who have amongst their workers outdoor or warehouse workers. The Department of Health and Human Services, or HHS, which we're going to talk about a little bit more in the next few segments, is one of the agencies that has implemented this important strategy. Now, notable resources that HHS has deployed that employers should be aware of today include the following: a heat risk tool that provides a 7-day advanced heat forecast nationwide and notes which levels of heat are dangerous to human health; a heat tracker tool that assesses the community burdens of heat and tracks emergency responses to heat situations; clinical guidance on heat and health, including materials for vulnerable at-risk populations; and a new Building Blocks for Heat Stress Prevention training program, which helps users, and users are our gathered audience today of employers and companies, identify and implement steps needed to reduce the risk of heat stress for workers in both indoor and outdoor environments.
Thank you for that look at newly updated workplace safety laws, Jeff. Links to the resources that Jeff mentioned are available within the WorkWise Compliance blog. Before we move on, I'd like to encourage everybody in attendance to follow our blog for labor law news and updates that we post regularly. A link to our blog our blog's homepage is in the chat window now.
Yes, thank you, Jeff. And as we move on to our next topic, we asked a poll question earlier about AI usage in the workplace. And it looks like a lot of people think they won't be using AI. And we know that sometimes some of these hiring tools like Indeed are using AI and we don't even know it. So just some things to consider. But as we jump into the next section, Jeff, we asked this question because the DOL did release information on AI in hiring and recruitment, correct?
Yes, that's right, Stephanie. So it's good to know anyway. And of course, as you mentioned, Although you may not think you want to use AI, there's a possibility that AI is using you. So it's good to know what's going on because there's a lot of context that could kind of filter into our workplaces. And I myself am a business owner, and I do deal with those resources. And very often you can see, especially in resume searching now, and this has been the case for a while, AI is very much involved through those various Indeed, LinkedIn, ZipRecruiter type websites, and sort of filtering resumes for keywords and helping employers along with that. So it may be in your life even if you don't know it. So let's talk about where the government gets involved with AI. In late 2024, the DOL published the AI and Inclusive Hiring Framework, a new toolkit designed to support the inclusive use of AI. What this means is that employers would inclusively need AI in their hiring technologies, and the government wants to step in to make sure that this use increases the benefits available to job seekers who are living with a disability. The agency believes that the framework they've provided will help employers reduce the risks of creating unintentional forms of discrimination, bias, and barriers to various accessibilities in the workplace as the employers implement AI hiring technologies. Conversely, the toolkit is also something that's available for workers and job seekers to navigate the potential benefits and challenges that they may face when they encounter AI-enabled technologies. Now, I want to jump into another resource that the DOL recently made available to employers. It's a new tool that provides ideas for reasonable accommodations, which kind of gives employers a leg up when dealing with an employee who's living with a disability, because the ADA, the Americans with Disabilities Act, requires employers who are faced with an employee advising them of a disability to provide an accommodation through something called the discussive process. So they and the employee facing the disability are supposed to go back and forth and communicate to try to find an accommodation in the workplace that allows that employee to do that job the same as an employee without a disability, and that's where the accommodation comes in. So what the DOL has done is they've put together a toolkit, a clearinghouse, a source of information based upon things that they've seen in their experience. To be more specific, the resource provided by DOL provides access to more than 700 accommodation ideas for workers with disabilities and for their employers to use. The Situations and Solutions Finder offers examples of workplace accommodations shared by users of the Job Accommodation Network, another government resource which the DOL uses and provides. This database draws its examples from large and small organizations across industries that cover both the public and the private sectors. As employers should be aware, an accommodation, as we said, is a modification of the work environment or how a job is typically done that enables a person who's otherwise qualified to do the job to enjoy equal opportunities in employment. That's something that's required and protected by the ADA. The ADA requires employers to provide reasonable accommodations for all disabled applicants, even at the hiring stage, and then after hiring for employees when they're requested to do so, unless doing so would cause something called an undue hardship.
All right, and from an HR perspective, I think that's a really useful tool, finding out what other businesses have done and how it could be applied to my business.
Yeah, I agree. So, Jeff, now I would like us to talk a little bit about updates regarding benefit plan compliance, but in the interest of time, could you just go over the main points that employers should be aware of?
Absolutely, Steph. I'll touch on some things that have changed over the past few months. Remember now, more information about any of these items that I've discussed and that our group has discussed today can be found in the 2025 New Year, New Laws e-guide that WorkWise Compliance is providing to all of its attendees for joining us today for this webinar. First, in November of 2024, the DOL and the Internal Revenue Service, and we all know them, the IRS, announced updates to its informational copies of the 2024 5500 series return report, and it verifies that employee benefit plans follow specific prescribed standards. Additionally, it ensures that participants, beneficiaries, and regulators all together have access to sufficient information about their rights under benefit plans. Basically, employers should ensure they are using the most updated version of Form 5500. Now, we're drawing your attention to that, and we often do that at these WorkWise lectures. You always want to check to make sure you have the most updated version of government forms so as to not sink your business or get in any kind of trouble using an outdated form. And the web is full of them, and WorkWise Compliance can steer you towards the right ones, and that's important because it does become a little bit confusing out there when you just do a Google search. So make sure you have the most up-to-date forms and you get them from the right folks. In September of 2024, the DOL, the HHS, and other federal agencies came together to issue final rules for clarifying and strengthening protections to expand equitable or equal access to mental health and substance use disorder care benefits. Most provisions of the final rules apply to group health plans and health insurance issuers that offer group health insurance coverage starting on the first day of the plan year that begins after January 1st, 2025, and then a few of these requirements will take full effect next year on January 1st, 2026. Next up, the HHS and other federal agencies issued a final rule under the Affordable Care Act, or the ACA, creating protections against discrimination in healthcare that's based on race, color, national origin, sex, age, gender, or disability. According to the agency, the rule will help increase meaningful access to healthcare for communities nationwide. That final rule went into effect on August 6, 2024. Finally, the IRS announced that the annual limit on health savings accounts, or HSAs, will now allow contributions for self-only coverage in 2025 of up to $4,300, a 3.6% increase from the $4,150 limit set for calendar year 2024. The HSA contribution limit for family coverage also goes up now to $8,550, and this is a 3% increase from last year's number of $8,300. Employers should verify that their HSA administrators are informing the employees of these limit changes so that those employees are able to maximize their benefits.
Thank you for touching on the benefit plan changes, Jeff. Although we've only discussed federal updates so far, we want the audience to know that many states have also passed new and updated laws and regulations that have or will go into effect soon. When creating employment laws, California and New York generally lead the charge in passing state and local legislation that many other states eventually follow suit on. Are there any important California and New York specific employment laws that employers in other areas may want to know?
Yes, Dan, that's a good point. So let's kind of do a flyover from coast to coast here. Many states usually let New York and California take the lead on legislation, and that makes some sense because New York and California are the states with two of the larger populations. Larger populations mean more legislation, more people represented with a wider range of issues. So like I said, we'll do a flyover. We'll start in California. Major California laws taking effect in 2025 include the following. SB 639 ensures workers with disabilities earn at least the standard minimum wage by ending new sub-minimum wage licenses and phasing out existing licenses. SB 988 guarantees freelancers earning more than $250 have written agreements setting forth the terms and conditions of their work. SB 1100 bars employers from requiring a driver's license as a condition of employment unless driving itself is part of the job. SB 1089 requires grocery stores and pharmacies to provide advance notice to workers and the community before closures. Now headed over to New York State also has some interesting laws that become effective in 2025. The state is introducing the nation's first paid prenatal leave law, requiring all employers to provide at least 20 hours of prenatal personal leave each year, in addition to the existing statutory sick leave provided by the New York State paid leave law. New York will also end, or as the legal term sometimes comes, sunset, paid COVID-19 emergency leave entitlements. Good riddance, COVID-19. We're tired of you. And then the state is also mandating the establishment of a workplace violence prevention policy, a mandatory notice and training program, and the installation of panic buttons in the workplace for certain retail employers.
Thank you, Jeff, for that look at California and New York. And like you said, a lot of the COVID emergency leaves are phasing away. So check even your local city and county. Some of the rules that they have are starting to go away. So although we don't focus much on other state laws during this webinar, do you see a particular trend in common legislation going into effect across the country?
Yes, Stephanie, there's a few of them. And once again, we'll do a flyover of many states and just talk about a few of those trends now. Changes and updates to workers' compensation laws are widespread, as related legislation related to each other, similar legislation, has taken effect in the states of Alaska, Colorado, Florida, Hawaii, Pennsylvania, and Rhode Island. The states of Colorado, Illinois, and Louisiana have all passed laws involving child labor and minor workers. Unemployment insurance updates are also trending, with bills becoming effective recently in Delaware, Louisiana, New Hampshire, and Vermont. Laws related to paid family and medical leave were recently enacted in Connecticut and Delaware. Finally, many states have added or made changes to their state labor law posters on specific topics. These states include Illinois, Maine, Minnesota, New York, Oregon, and Washington, where posters now contain information on employer-sponsored, also known as captive audience meetings. Similarly, depending on employee size, the states of Indiana, Louisiana, Massachusetts, Minnesota, New Hampshire, and New York now have poster requirements that posters exist and be seen by all in public places, in the workplace, that contain notices about veterans benefits.
Thanks, Jeff, for that glimpse into laws taking effect across the nation.
I also want to remind our audience they can access a full list of new and updated laws and regulations for all states that have or will go into effect soon by downloading that 2025 New Year, New Laws e-guide.
All right, and as we close out the information portion of our webinar, it's important to note that at the beginning of the new year, certain states, counties, and local municipalities increase minimum wage rates for employees. In addition to the 2025 minimum wage map that we're providing, you can find a complete list of municipal minimum wage changes within the 2025 New Year, New Laws e-guide. It's important to mention that when it comes to minimum wage, most states and municipalities require the posting or distribution of updated minimum wage posters. Between 2024 and 2025, 19 states alone released updated minimum wage posters. That doesn't count other municipal or conditional notices you might be required to display. WorkWise Compliance is here to help with poster compliance. Current subscribers can access all required posters and notices within our digital resource library, which I'll touch on later. If you have any questions about your subscription or becoming a subscriber, please contact our customer service specialist using the number in the chat window.
I would again like to thank you, Jeff, for all the great information you've shared with us today. And before we move on to that live Q&A session, we just have one last poll question we'd like to ask our audience. So would you be interested in attending future webinars on the following topics? How to respond to workers' compensation claims, best practices in creating and implementing an emergency action plan, how to maintain workplace privacy and proper cybersecurity, President Donald Trump's first 100 days in office, an employment law perspective, or I'm not interested in any of these topics, and you can select all that apply here. And just keep in mind, you can start asking your questions in the box now in the chat in the questions window. So for Jeff to answer here soon. If we don't get to them, they will be answered later. So and Dan will talk on that. I just want you to know while you're waiting here, you can go ahead and submit. All right, looks like our voting ended. So it looks like we have some interest in responding to workers' compensation claims and Donald Trump's first 100 days. So thanks. We'll keep that in mind. Thank you for your responses.
All right. And to participate in today's Q&A session, I encourage everyone to submit questions through the questions feature in GoToWebinar. We'll do our best to get through the most relevant audience questions throughout today's Q&A session, and all unanswered questions will be submitted to our guest speaker for responses and sent to you via email. Please note that after the Q&A portion, Jeff will provide his key takeaways from today's session.
All right.
With
So
that,
as
let's look at our first question. Sorry.
Oops, sorry. Sorry to cut you off, Dan, there. So yeah, let's look at those. We like to put them on the board so you can see them here. So Jeff, based on your experience, how soon do you think we can expect changes to employment law under this administration?
That's a great and timely question, and thank you to our member of the audience who asked it. Most likely, we will see changes to come by way of executive orders. For those following the news, that was something that was a very big part of Inauguration Day on the 20th. I guess real quick, a civics lesson. There's three branches of government, as we all know. There's the executive, the judiciary, and the legislative. That's the Supreme Court, Congress, and presidency for the sake of this conversation. You'll see executive orders first, in my opinion. We've already seen those. Those are the control of various agencies. We've named a lot of agencies today. They have all those cute acronyms we try to get through. What you'll see is you'll see a lot of executive orders related to those agencies and their function. Things will change first that way. The executive orders might be challenged to the courts. Then we'll see the courts interaction next. That'll probably happen after this first 100 days or so, or towards the back end of it. And then a lot of people are anticipating that after the executive and the judiciary kind of work it out, the midterm elections, which occur in 2026, which will be a major opportunity to shift the balance of power in Congress, that period of time, sort of from the summer to the fall of 2026, is when we'll start to see a lot of attempts from the legislature to change things. There's also one very large bill going through that, or maybe broken into a few pieces, that's probably going to do some changes up front, but then we'll wait to see big changes from the legislature until it's time to try to hold those seats or lose those seats summer to fall of 2026. So I would say executive, judiciary, and then legislative will be the order of things over the next period of time.
Thanks for answering that timeline question, Jeff. Let's get another question on the board here so we can get some more answered. So our next question for you will be up in a moment.
Wait, ready. Let's do it.
Okay, yeah, it should be here in a second. These technical difficulties. Thanks everyone for bearing with us. All right, and maybe I can get it pinged here in the chat window instead.
Or just read it out to me. Ready to go. No worries.
Yeah, we can see what other questions we might have here. What do you recommend businesses do to communicate any changes in employment laws or policies to employees effectively?
That's a great question again from our audience, and thank you. That's a question we've heard before in these presentations, and the answer remains the same. There's great ways to communicate information to employees. Technology can be a help or a hindrance, but I think in this case it's mostly a help. The best thing to do is to try to the old-fashioned way, and a way that I still sometimes like, is the walking around and dropping memos in people's physical inboxes that say, this is an update to our policies based on the law. Please look at this, read it, sign it, and give it back to HR. That's the old-fangled way. I don't know if everybody wants to do that anymore. The other way to do that is to circulate the same types of information via email. And then the other way to do it is to circulate the same information via a share drive, which a lot of my corporate clients do. They have a robust share drive where their employee manual, as well as their up-to-date policies, are all included. The employee manual incorporates the policies. And the most important thing, no matter which of these methods you use, is always have your employees sign off on receiving and understanding and acknowledging the requirements that the company is now putting upon them. That receipt is very important. That receipt acknowledgement is very important for compliance purposes and as a defense in the event that a litigation or an agency action is raised against the company. So try to keep good records of all of that.
Yeah, definitely. I can't tell you how many times Dan here has sent me a DocuSign, so we're very, very familiar with those. All right, another question for you here. So we have audience question that's just asking, what is a non-compete?
That's a good question. What is a non-compete? Well, a non-compete is a general term, sort of a shorthand term, a slang term, that we've been using in labor law to describe essentially two kinds of scenarios. One of them is a specific agreement that includes a specific agreement that focuses on non-competition. That would be an agreement that tells the employee that for a certain period of time, for a certain geographic distance from where the company is, they are not allowed to compete with the company. And it may say they can't compete with the company by working with a competitor of the company, by engaging in any activities that are against the business interests of the company, or that utilize any company information against the company. And these usually apply, and that's the type of agreement. Now, the other thing is a clause like that you might see inside of an employee agreement if an employee signs a contract to work with you. It's usually then just a clause. You may also see it in something called an NDA, a non-disclosure agreement, or the international version of that, which is called an NNN, which is a non-competition, non-use, and non-circumvention agreement. They'll either be a full agreement just about non-competition, or you may see it as a clause in something else. But basically, the basic idea is that it restricts the employee's ability to work competitively against the company, usually during the time they work there and usually for some duration afterwards. And employers rely upon this to protect things like their trade secrets, their confidential information, and obviously their ability to themselves succeed and thrive in the workplace.
Got it. Thanks, Jeff, for answering that for us. We have another question here. Should HR professionals receive specific training on reviewing and drafting complaint contracts, and what areas should be prioritized?
I think that's a great thing in terms of drafting compliant contracts and contracts that agree with all the laws we've discussed today. Particularly, we've talked earlier today in the WorkWise Compliance seminar that we're doing here, we talked about how the federal government has a list of no-nos and things not to include. We've talked about the status of non-competition agreements and or clauses and how they can both be allowed, but at the same time restricted by certain state requirements, like in California, where they're almost completely banned. And I think that the best way to go about it is for the HR professionals to share a standard employee contract with an attorney or with an HR professional, take a look at it together, and then figure out where the problem areas might be, and then from there the training can follow. There is a right way to do this and a wrong way to do this that involves compliance with all applicable laws. I do these contracts all the time for companies, and I think it is important. The training could be, essentially the training is what comes out of the process. The company hands me a contract, asks me what's wrong with it, I redline it for them, I send them back, we talk about it a little bit, and then I may not hear from them again for 6 months. Well, that probably means that they've been trained by that process, and now they know what to do until the next period of time passes. So the training is kind of through the exercise of the review, but I do think the training is important. I do think that allows companies to sort of leave my nest as a lawyer. Like they can then, go out and fly and thrive on their own because they know what to do. So.
Yeah, definitely. All right, thanks, Jeff. Again, keep the questions coming. If Jeff can't get to them right now, he will get you a written answer, and it'll be sent to you via email. So definitely stick around and get those questions in. And we have, I think we'll do our last question here. This one you may or may not have information on. Obviously, it's a really relevant, time-sensitive one. It's asking, does President Trump's executive order no longer make gender a protected class?
I do know the answer to that question. So gender being a protected class is something that's come out of a long line of Supreme Court decision making over the last several years. Gender encompassing so gender as a protected classification is based on a complex argument of how sex discrimination works, which is the original protected class. Generally speaking, the various types of gender, which include gender identification, gender expression, those have all been basically brought under the umbrella of sex-based discrimination. And that's a Supreme Court line of case precedent that has been challenged and under the current Supreme Court justices has begun to erode. Notwithstanding that situation, an executive order by the presidency, I'm going to get in trouble here because I know there's a lot of conversation about this, but an executive order by the presidency is not capable of overturning Supreme Court precedent. That's just not how it works. What an executive order does is it then tells the agencies to do things. So gender discrimination, for example, that might be something where it tells an agency, you no longer have to behave this way or act this way in terms of enforcement, in terms of your own operation, because agencies are also employers. And then what will happen inevitably is one of those executive orders will find its way to the Supreme Court, probably on a challenge. And then what the Supreme Court decides will become the law of the land. It's a little complex. I mean, the president can pass the executive orders, he can direct the agencies can follow them and have to follow them, but it's likely that there'll be a legal challenge. So it doesn't automatically, I know this has been brought up in a few contexts, it doesn't really automatically overturn Supreme Court precedent. There is an old case called Marbury versus Madison for our Supreme Court scholars, of which I hope for the sake of their sanities, there's few. But in that situation, there's a statement by the Supreme Court in the very beginning of our country that says the Supreme Court's determinations are the law of the land. So it's actually very difficult for anybody to overrule the Supreme Court, including by executive order.
That makes sense. And if you have further questions on how that pertains to your company or business, feel free to put it in that question box. All right, so unfortunately, we run out of time on the questions. All unanswered questions will be forwarded to Jeff via email, and his responses will be sent to attendees in the coming days. Thanks to everyone who submitted questions for today's session, and thank you so much, Jeff, for taking the time to answer them. Another reminder, you can access our 2025 New Year, New Laws e-guide along with today's slide presentation and the 2025 minimum wage map attached as handouts in GoToWebinar. Jeff, can you please leave us with any key takeaways on the labor and employment laws that we discussed today?
Yes, absolutely, Steph. And I want to thank you both and thank everyone for attending today. I'm going to do this last kind of one as a lightning round. You've got them up on your screen there as well. Here's a few important takeaways. Make sure to be aware of the federal, state, and local laws that affect your workplace. For clarification on what your specific business needs to comply with, contact your legal representatives or your HR folks. Review your employee handbooks and policies and eliminate anything inside that could be considered as an unfair bargaining practice or anything written specifically to look like fine print or in a way that seems too complex for the average reader. Note that the single-party control of both the presidency and the Congress could mean that employment law changes are around the corner. Employers should stay on top of all updates that might affect their own workplace. Employers can continue using and requiring non-compete agreements as long as they follow the rules of their states. The rollback on federal overtime exemptions has taken place. However, be careful with the July 1st, 2024 application of the old rule because taking steps against that could be considered an adverse employment action. And finally, if your company uses AI in hiring and recruitment, make sure you're following the DOL's newly released guidance on that subject.
Thanks for all the key takeaways, Jeff. All attendees will receive a follow-up email with the certificate of proof of attendance along with the recording of today's webinar.
And this concludes today's webinar. Thank you for attending our presentation and bearing with on the tech issues. We hope you have found this information helpful in understanding critical employment law updates taking effect in 2025. Thanks again to Jeff for being our guest attorney. We look forward to continuing to work with you on future presentations.
Thank you, Dan and Stephanie. A true pleasure.
All right, and if you enjoyed today's session, we invite you to view past webinars on demand within our digital resource library. You can access checklists, forms, and training materials that address topics discussed in today's session. To register your account and access the library, click the link in the chat window now. If you've already registered for the digital resource library, click the second link in the chat window to log in. And if you have any questions about the Digital Resource Library or WorkWise Compliance, please contact one of our customer service representatives today. The phone number is currently in the chat window.
And to all of our attendees, thank you for choosing WorkWise Compliance as your provider of labor law compliance solutions. We'd like to ask you to please participate in a short survey that will become available at the end of this webinar session. Have a good afternoon, everyone.